Thank you so much for coming to this event. I think it might be the first one of its kind at the law school, which is very exciting. We have a lovely panel with us today, Barbara Harvey and Rima Kapitan, and Abdeen Jabara is going to introduce them properly. I'm just going to introduce Abdeen. Abdeen is a civil rights lawyer, formerly Michigan-based, now New York-based. He's done a lot of work for the civil rights of Arab Americans and Arabs in the United States, a lot on surveillance and collection of information about them, and he's been very involved in the National Lawyers Guild delegation to the Middle East. So please welcome Abdeen Jabara. Thank you.
And welcome all of you. This is an important event. I think this may be the first BDS forum that has been convened in New York, certainly at NYU Law School, to the best of my knowledge. And I want to thank Antonia and the National Lawyers Guild and Jewish Voice for Peace, Adela, New York, Center for Constitutional Rights, New Yorkers Against the Cornell Technion Partnership, NYU Students for Justice in Palestine, and the Muslim Law Students Association of Fordham University for endorsing this event. So, without further ado, I would just like to briefly say that coming in here this evening, I met a professor here at the law school that I know, and she was surprised to see me, and she asked me what I was doing here, and I said I'm here for a forum on BDS, and she looked quizzically at me. And I understand that, because I think that people don't know what BDS is. And so this forum and other forums and our work is to help people understand what BDS is. That's why we're here. We want to explain it, we want people to understand it, and we want it to grow. And I'm going to begin by just reading the first paragraph of something from Wikipedia on boycotts of Israel. It says, boycotts of Israel are economic and political cultural campaigns of action that seek a selective or total cutting off of ties with the State of Israel, Israelis, or Israeli corporations. Such campaigns are employed by those who challenge the legitimacy of Israel's policies or actions toward the Palestinians over the course of the Arab-Israeli and Israeli-Palestinian conflict, oppose Israeli territorial claims in the West Bank or Jerusalem, or even oppose Israel's right to exist. It doesn't say right to exist as a Jewish state or what have you, and then it says in brackets, citations needed. So, yes, citations are needed, and we are here to help provide some information that will help fill in those gaps. Now, as this correctly states, there are different concepts and different ideas about what BDS is. What it is that should be boycotted, what it is that should be divested, and what it is that should be sanctioned. And historically, so far, with the beginning of the BDS movement, the progress has occurred more in Europe for obvious reasons than here in the United States. But there has been some important advances here in the United States. For instance, in 2004, the General Assembly of the Presbyterian Church voted to initiate a process of phased selective divestment in multinational corporations' operations in Israel. And in Canada, to the north of us, in May of 2006, the Ontario section of the Canadian Union of Public Employees approved a resolution to support the international campaign of boycott, divestment, and sanctions against Israel until that state recognized the Palestinian right of self-determination. There have been several other occasions where here in North America, because Canada is part of North America, we've had some significant successes. As you know, or some of you may know, in July of 2010, the Olympia Washington Food Co-op in the state of Washington voted to stop selling product from Israel into its grocery stores. And that case actually went to court. One of the co-op board members brought a lawsuit against that, and the judge tossed it out and actually made him pay attorney's fees. But then, of course, here in New York City, and this is the collector's item that I told my friends that I would raise, the Brooklyn Food Co-op also had a campaign to initiate a boycott on about 5 Israeli products that were being sold in the Brooklyn Food Co-op. That was an enormously educational effort, and one of our beloved CODSE members, Mitchell Cohen's here. He was heavily involved in that, and I really want to give a round of applause personally to the members of the Brooklyn Food Co-op that carried on that struggle. Even though they ultimately lost, it was a victory.
Park Slope Food Co-op.
Park Slope, excuse me, correction. How many people here are members of the Park Slope Food Co-op? Okay, so that's not that many, but it's good that you're here. It's good that that campaign was a marvelous campaign because it raised a great deal of consciousness. And sometimes you can have success without victory, and I think that was one of those occasions. Now, it's not too difficult to say that the greatest area where the boycott, sanctions, and the divestment movement has been successful in the United States has been in the area of the cultural and artistic elements. Number of singers, actors, artists have refused to go to Israel, have indicated why they weren't going to Israel. And that is understandable as well, because they are not so much enmeshed in the total political, economic dynamic of this, and they don't have to answer to the same kind of powers that be, and they have their own support base, so that they have been able to do this with more independence than other areas. Only one American company has engaged in any kind of a divestment, and that was when Caterpillar was removed from the 3 socially responsible stock indices by the American investment firm MSCI. MSCI specifically cited as Israel's use of Caterpillar bulldozers in the Palestinian territories as a key reason for its decision. And I'm sure that Rachel Corrie's case was a primary motivator for that. Rachel Corrie's case was, I'm sure most of you know the details in that case, but that was a watershed moment in public consciousness about what Israel is doing, not because another Palestinian was killed. They're killed every day. But here was a young, white, American, beautiful college student who had gone there to help Palestinians and was killed by a Caterpillar bulldozer that was specially fitted for house demolitions and what have you. So let me just summarize this before I introduce our panel here. The chief proponents for some iteration of BDS have been churches, trade unions, food cooperatives, professors and lecturers, artists and musicians and actors, and the BDS movement has been considerably more successful in Europe than in the US. Again, for reasons that you can, I think, understand. Now, this evening, we have two individuals who have very graciously and generously come to New York from Detroit and Chicago, and I've just got to find their bios and then we can be on our way here. The first one is Barbara Harvey. I've known Barbara Harvey since...
Never mind.
Okay, never mind. Any case, Barbara, and I'm going to just read this, after a stint as a law professor, that's at Wayne State University, Barbara missed the intensity of litigation practice and became a plaintiff civil rights and civil liberties attorney as a Michigan ACLU legal director, focusing on free speech and equal rights issues. She drafted an anti-surveillance ordinance for Detroit, one of the first in the nation. Our beloved Coleman Young vetoed that. She dedicated most of her legal career to fighting for the rights of workers within their union, being convinced that organized labor needed to get back in touch with its members to regain its power. And she has had an illustrious career defending union dissidents and trying to bring democracy to their unions. And she currently serves as general counsel to the Teamsters for a Democratic Union, the largest and oldest caucus of union members in the world. So Barbara's strategic litigation work in the union reform movement was good preparation for the work she's doing today in the BDS movement. She told me earlier today about the work she's doing. It's absolutely phenomenal, wonderful work, and she's putting her heart and soul into this work, and her work with the JVP has been part of that, and with the student groups around the country. So without further ado, I would like to ask Barbara will come up here, and then after she completes her presentation, we will have our next speaker come up, and then we will have a question and answer period.
Thank you, Abby. Well, there's a lot of ground to cover. I'm going to dive in, and we have to leave time for Q&A, which is more important than anything else. And most of the interesting stuff will come out that way. It always does. So I'm going to kind of briefly recap the history of the BDS movement in this country, and talk about some of the ways in which it has been attacked and my analysis of some of that, and leave the rest to come out in Q&A. In 2005, Palestinian civil society, pretty much all of it, it's a small, very small population, 173 NGOs and 71 members of parliament, political parties, and unions in Jordan all agreed to commit to nonviolent economic resistance to occupation. And they put out a call for global boycott, divestment, and sanctions against Israel. They have articulated 3 goals. They have a website if you want to see details of it. It's a massive database by now called, I'm going to get this wrong, bdsmovement.org, or that. Just Google BNC ampersand BDS and you'll go right to it. The goals are 3. The first one is an end to the occupation, including return to the Green Line, pre-1967 Green Line. The second is equal rights for Palestinian citizens of Israel. And the third is recognition of the right of return of the Palestinians in the diaspora. Those are the goals of the BDS movement, and I, with admiration at this point, can comment that the organizers have been extremely tolerant and open and welcoming of all interpretations of activism appropriate to a particular group for the purpose of achieving those goals. So what unites the BDS movement are its goals. And many people now are working in various ways to achieve those goals. The BNC call is for BDS against Israel. Much of the work in the US focuses specifically on anti-occupation BDS activism. And this, in turn, comes out in many ways. A boycott against Israel focuses on the state of Israel, official, that is, support, official state policy, and private people who benefit from such support in their own economic activity. BDS against the occupation focuses against all companies globally that profit from or support the occupation. So in that respect, it's broader than the BNC call, because it looks to boycott, divest, and sanction all companies that engage in profiting or support for the occupation, whereas the BNC call addresses only Israeli official policy. In a way, it's more narrow in that it does not necessarily encompass all Israeli business, although more than 80% of the Israeli economy is actually engaged in business that profits from the Israeli occupation. So it's perhaps a more conceptual distinction than anything else, but it's particularly, as a tactical strategy in the United States, effective to focus on misconduct, which is the focus of anti-occupation, boycott, divestment, and sanctions work. The BNC call is very attractive because it focuses on really basic rights that every human being should have. For example, a country to belong to, water for crops, unpolluted water to drink, and education, the right not to languish in prison for years without being charged with anything and without a hearing, the right to travel from home to market, to sell veggies and to buy things, the right to travel to hospitals to deliver a baby, the right to put a toe in the ocean that can be seen from every hilltop in Palestine, but many people are born and die in Palestine without ever being able to set a toe in the Mediterranean. The right to farm the land that has been farmed by your ancestors for centuries, and the right to freedom and dignity. The BNC call absolutely electrified Europe, and the response from Europe has been quite intense. And I'll tell you a story about one company in particular a little bit later on, named Veolia, a French company, and how the movement in Europe has affected it. It's an amazing story. In Europe, there's much more information about news and in the media about the Israeli occupation and what it is, what it does, and the Palestinian perspective appears in print. In the US, it hasn't been that way. There's been voluntary self-censorship, and it was Abdeen who actually brought my attention to it. I thought I was a well-educated person, but boy, I had no idea how pervasive media self-censorship was. And BDS has had quite an impact already in helping to break that media self-censorship blockade. It's quite different now that we have seen some BDS activism in the US. Not that there's not a long way to go, but things have changed a lot, perhaps with many thanks to Benjamin Netanyahu. So, where is the BDS movement now in this country? Well, starting in the spring of 2009, when an amazing thing happened, Hampshire College actually divested from the occupation in its own portfolios, following a campaign, a student campaign. It denied that it was responding to the student campaign. It said that what it was doing was, engaging in a periodic review of its portfolios for compliance with all more recent investments, with its socially responsible investing criteria, SRI criteria. And lo and behold, they ended up disqualifying the targets of the BDS campaign on campus. And essentially, the students won their campaign, despite the denials. Which is probably how it will always be in this country until it's no longer a political issue. We just have to accept that as a fact of life in movement activism. In June of 2010, JVP, Jewish Voice for Peace, launched a campaign against the TIA-8CRAF to divest from the occupation. Do people know what TIA-8CRAF is? It's like the ultimate nerd campaign. TIA-8CRAF is an enormous, one of the top 50 Fortune 50 companies. It has over $500 billion that it invests both in its own accounts, own mutual funds, and those that it manages. And it is the primary, overwhelmingly, the primary source for retirement annuities by faculty across the country in both private and public sectors. And in places where it is not the chosen source of retirement income, such as California, it participates in managing the state's teacher retirement fund. So, as a strategic target, it was excellent as a vehicle for engaging students in BDS activism and educating educators and students about why such activism, we in JVP, I wear two hats, JVP and also NLG, why we feel that it's an appropriate way to spend our energies. And in July of 2010, JVP held its regular annual meeting in New York City, and JVPers went to the meeting and entirely monopolized the annual meeting. And first there are elections, which take 5 minutes or less, and then there's a financial report, and then the rest of the meeting, which is 2 hours plus, is dedicated to Q&A from the shareholders who are technically participants, get to ask questions of the CEO, Roger Ferguson, a former federal member of the Federal Reserve Board, and I believe one of Mr. Obama's teachers at Harvard. Very, very smart human being. And it's a chance to speak for 2 hours with the CEO of TIA-8CRAF face to face. So a bunch of us went, and in the course of questions that we kept, presenting to him, courteously. Others who knew nothing about our campaign started also to get up and ask questions. Yeah, we want answers to these questions too. And the whole room was beginning to ask questions. And it only ended when the meeting ended. It was an amazing experience. A little while later, in November of 2010, the Jewish Federation Convention was held in Washington, D.C., with the guest of honor, the speaker being Netanyahu. And at that point, the big line from Israel was the delegitimization of Israel. That was the first response to BDS. It delegitimizes Israel. And he started to talk about the delegitimization of Israel in his presentation, when all of a sudden this student jumped up and unfurled a banner that said the words that she expressed: "No, the siege of Gaza delegitimizes Israel." And she sat down. And nothing like this had ever happened at any Jewish Federation convention before. And for a moment there was stunned silence and then bedlam. Eventually people quieted down and he continued and went on his way and started talking again about delegitimization. And in another few minutes someone else stood up and said with his banner, "The occupation delegitimizes Israel." Another furor. And each one of these protesters was escorted out by the private police. And to shorten things up, in the course of this, other students sprang up in the course of his presentation. The settlements delegitimize Israel. The loyalty oath, which was the oath that was being proposed of Palestinian citizens of Israel, aka Arabs. The word Palestinian citizens of Israel, that phrase does not appear in Israeli discourse. It was a proposal to have Palestinian citizens of Israel swear their allegiance to Israel as a Jewish state. And finally, silencing dissent delegitimizes Israel. And in fact, Israel has subsequently passed a law, adopted a law, that makes it illegal to advocate BDS in Israel. Israel, many people do not know, does not have a constitution, as we do here. If it were to have a constitution, what constitution could you have without a guarantee of equal rights? So Israel also does not have free speech, technically, although there generally is free speech for at least the Israeli citizens of Israel, the Jewish citizens of Israel. So this law does not make it illegal for companies to comply with BDS pressure. It only makes the advocacy of BDS illegal. Something that would be astonishingly unconstitutional under the First Amendment of the United States Constitution. Advocacy is the highest, most highly protected form of speech under the U.S. Constitution. There is no higher protection afforded any variety of speech than advocacy. One of the reasons to engage in BDS is to fight the insidious influence upon U.S. democratic basic principles of the Israeli occupation, which it is in fact having. In July of 2011, TIAA-CREF moved its annual meeting to Charlotte, North Carolina. We think to escape us. But Archbishop Tutu greeted the meeting with an editorial in the Charlotte Observer praising BDS and beseeching TIAA-CREF to please divest from the occupation. And a whole bunch of I said TDUers, JV peers followed TIA aircraft to Charlotte, and again, totally monopolized the Q&A at the meeting. In September of 2011, Roger Ferguson came to Detroit, where I'm from, to give a presentation on retirement and retirement issues at Wayne State University in Detroit. And as people walked in to their seats, to this auditorium, 700 plus seat auditorium at Wayne, there was a little sheet of paper, two-sided, on each seat, which was a joint statement by 13 faith-based organizations in the Michigan area, in Detroit and Michigan, and not outside it. And a number of prominent individuals asking TIA aircraft to divest from the occupation, despite the efforts of the campus security to prevent us from bringing anything, whatever, into the auditorium. Someone managed to get every seat in that auditorium. And when he opened the floor at the end of his presentation to a completely packed house, every single speaker who lined up at the microphone demanded answers to questions about, different questions, each one had a different question about why TIA had not divested from the occupation. So that was just a horrible ordeal for poor Mr. Ferguson, who I happen to like. I mean, he's a really admirable human being, it seems. We sabotaged him again. That's called bird dogging, that technique, and needs to be used very judiciously to avoid alienating your audience. In May of 2012, TIA aircraft divested from Caterpillar in all of its SRI, socially responsible investing accounts. The largest divestment action in the United States. The first really major commercial divestment action in the United States. $73 million, which is literally a drop in its bucket. Leaving, and by the way, leaving more than $900 million in its non-SRI accounts invested in Caterpillar. But it was a huge step and implies that TIA aircraft is open to divesting from the occupation in its SRI accounts. This was a decision that TIA aircraft said had nothing whatever to do with our campaign. It was a decision rather that reflected an action by its screening company, the company that decides which investments, which companies to invest in for a certain mutual fund. So if you have a mutual fund that's for growth, here are the companies that are good for investing in for that purpose. If you have a group of funds that are for socially responsible investing, it has several different varieties of screens for socially responsible investing, which I understand to be the largest growing area of investment nowadays. And the name of the company that is its screening company starts with Morgan Stanley. We had sat down with Morgan Stanley earlier that year. Morgan Stanley, something, I can never remember the full name. It's MSCI, I forget what the CI stands for. Oh no. And told Morgan Stanley why we believe they should delist Caterpillar from their SRI screens. Well, MSCI did delist Caterpillar, as Abdeen noted, and the triggering factor was its really abominable labor relations actions in Canada in closing a plant that was the object of a labor strike and sending the work to a lower wage jurisdiction, aka the United States. But it admitted that a key factor had been the sale of military compatible D9 bulldozers to Israel, where they are fitted with weapons and armor plating and sent off to bulldoze Palestinian homes and worse. They then withdrew later that announcement and substituted something that made no reference whatever to that key factor. So you will not find it online anymore, although we have hard copies of it in our files to prove that it was out there at one time earlier. I've just been told I basically have only a minute or so left, and I haven't started to talk about what's happening on campus, which is really important. Let me just take a few minutes to tell you that, and let's try to spend some time on that in Q&A, because it's really where the movement is at, in a very real sense, in the churches and on campus. And if we can win the battle on campus, the battle will be won, because those are the wage earners, the investors in TIAA craft and elsewhere of the future, and the decision makers of the future. Students for Justice in Palestine started out at a conference in Hampshire College. I think it was 2009, that was the first conference. It now has more than 100 chapters, one chapter per campus. It's an amazing network of organizations. Sharat Hadin, the Israel Law Center, is an Israeli law center in Israel that had its US office send a letter to 150 colleges and universities in this country, basically threatening to sue them should they have the temerity to treat equally the SJP and Muslim Student Association affiliate chapters on their campuses, because, as we know, they have the propensity to become terrorists. And, you will be encouraging, and they are anti-Semitic, and therefore, you're encouraging hate speech and the cultivation of future terrorists. Essentially demanding unconstitutional and illegal conduct by these colleges and universities under threat of being sued by a country that doesn't subscribe to those rights. If any other country in the world had done anything like that, can you imagine the furor? But how many people here in this room have even read about it anywhere? 3. And you are the activists and the people who are interested on both sides of the issue. Well, the National Lawyers Guild put together a letter that was a detailed response to the Sharat Hadin threat, and sent it to the same list of colleges and universities, explaining why what Sharat Hadin was demanding was completely unlawful under Title VI and of the Civil Rights Act, and under the Constitution's Equal Protection Clause, as well as the First Amendment, which entitles free speech, these groups to have the same free speech rights as everybody else. And following that, it became harder to engage in activism, because these schools all felt that it was necessary to do their due diligence to show that they had turned every stone to make sure that everything was okay that was going on in their campus, knowing full well that if they actually acted against to implement the demands of Sharat Hadin, they would actually be in violation of the law. And I'm going to finish in 30 seconds or less. The upshot of all of this just happened a few weeks ago, when the Department of Education's Office of Civil Rights dismissed all 3 remaining pending complaints against universities for violating Title VI that had been filed in support of the Sharat Hadin position, because each one said the students did nothing illegal under Title VI. They were just engaging in political advocacy, which is a protected right under the Constitution.
Thank you so much, Barbara, for that. I'm sure everyone here appreciated the detailed information you gave about the TIAA Craft campaign and what is happening on the campuses, and I'm sure we can explore that further. The next speaker, Rima Kapitan, is owner of Kapitan Law Office. Her practice consists primarily of litigation on behalf of employees and advising of businesses on employment law matters. In recent years, she's increasingly focused on academic cases representing employees in appeals of tenure denials and employment litigation in free speech and discrimination cases. She's spoken on the topic of academic freedom at conferences of the American Association of University Professors, the Illinois AAUP, and California State University Fresno. She served as a judge at the Philip C. Jessup International Law Moot Court Competition. Ms. Capitan is a graduate of DePaul University College of Law and Indiana University's individualized major program. She was admitted to practice by the state of Illinois Supreme Court in 2005. She is a member of the United States Court of Appeals for the Seventh Circuit and the United States District Court for the Northern, Central, and Southern Districts of Illinois. Please welcome Ms. Capitan.
Thank you, Dean, and thank you also to the National Lawyers Guild here at NYU, and also to Code Z and Terry Ginsburg especially for organizing this event. And I know that Code Z is a controversial pronunciation, so however you prefer to pronounce it. So I'm talking today about, I'll briefly summarize the goals of BDS, although that's been discussed a little bit, and I will argue that the elimination of Zionism should itself be one of the goals of BDS. And I'll also talk about one of the most controversial aspects of BDS in terms of tactics, which is the academic boycott. And I'll argue that the boycott is legitimate and focus on the position of the American Association of University Professors, the AAUP. So the goals of BDS are written on its website, and basically they call for Israel to follow international law, and they advocate a number of tactics of boycott and divestment and sanctions with the aim of forcing Israel, pressuring Israel to comply with international law. And specifically, they call for the ending Israel's, quote, occupation and colonization of all Arab lands and dismantling the wall. They call for recognizing the fundamental rights of the Arab Palestinian citizens of Israel to full equality, and respecting, protecting, and promoting the rights of Palestinian refugees to return to their homes and properties as stipulated in UN Resolution 194. As many BDS activists themselves and critics of the BDS movement have argued or acknowledged, if these goals are all actually implemented, what will result is the end of Israel as a Jewish state, as a state that privileges Jews over non-Jews. And Zionism, if these principles are all adhered to, can no longer be the governing principle of the state of Israel. And many have interpreted the BDS goals, and in fact many in BDS argue that in fact the goals of BDS are limited to opposing the occupation and ending the occupation of the West Bank and Gaza, and destroying the settlements or dismantling the settlements. And in fact, many who've heeded the boycott call have limited themselves to divesting from the occupation. So for example, the European Union recently made a decision to divest from, not to enter into economic agreements that include doing business with the settlements. And this was, of course, a big step. It's the first time the European Union has actually used the tactic, has endorsed the tactic of boycott. But it's also very limited. The European Union is still free to do business with Israel, which of course is behind the occupation, but also what it does is to continue to legitimize the state of Israel as a Jewish state, as a state that privileges one religious group over others. And I think it's a mistake not to openly call for, as one of the goals of BDS, ending Zionism, if you define Zionism as having a state in Palestine in which the majority population, if you include the West Bank and Gaza and the refugees, is not Jewish. So having a state for Jews in an area that's not primarily Jewish. And in fact, many, including Norman Finkelstein, have criticized the BDS movement for this reason, perhaps falsely assuming that the real, secret goal of BDS is eliminating Israel. And he says, this is Professor Norman Finkelstein, he says that the basis for solving the conflict has to be what international law says. We have to look at what international law has to say. And he says there's near unanimous consensus on what the law says. The settlements are illegal, East Jerusalem is occupied Palestinian territory, but it's also correct that Israel is a state. That's also the law. And he doesn't make a distinction between Israel being recognized as a state and Israel being legitimate, as legitimacy is normally defined in international law. And he says that the International Court of Justice and numerous UN resolutions have also a two-state solution, which I'm going to argue later is not true. And Finkelstein and others employ overwrought rhetoric in an attempt to prevent BDS activists and others from stating openly that one of the goals of BDS is ending Zionism as it's currently defined in practice. And they even use violent rhetoric to describe what is at its core a nonviolent movement, what is in totality a nonviolent movement. Historian Harold Brackman said that BDS is quote, a key component of the global asymmetrical war on the Jewish state. It's committed not to peace, but to a piecemeal elimination of Israel. The efforts against Israel on campuses constituted an academic jihad. And Norman Finkelstein says that the BDS movement, they say they want to enforce the law and they really want to eliminate Israel. That's a familiar term to all of you, I'm sure. He says that, according to BDS, quote, Israel has to be effaced from the world's map. So they're using the rhetoric of ethnic cleansing and war and terrorism and violence to describe what is a nonviolent movement aimed at ensuring respect of international law and equality. And as you all know, law is in fact a contested space. That's why many of you are here studying law, so you can learn how to participate in that contestation. Law is neither static nor always rooted in justice, and both the existence of certain laws and their interpretation should be constantly re-examined and tested. In the United States in the 1940s, the law said that the internment of Japanese citizens and residents based on national origin was legal. The International Court of Justice has ruled on the legality of Israel's wall in the West Bank, and according to Finkelstein, it ruled that the West Bank and Gaza are the unit of self-determination for the Palestinian people. He claims that it's up to the Court of Justice to decide what the self-determination of the Palestinian people entails and how it should be exercised, and that they've decided that there is to be a two-state solution. I think he's wrong that the International Court of Justice, that question was before it and that it ruled in that manner. In fact, it reaffirmed the principle of self-determination within its opinion, and it recognized that the conflict is ongoing and that the border has not yet been established between Israel and the Palestinian territories. As Professor Virginia Tilley points out, Norman Finkelstein wants to respect the law, but he argues against respecting UN Resolution 194, which calls for the return of Palestinian refugees. And if we allow the return of Palestinian refugees, that in itself would undermine Zionism, since it would change the demographics of the area. And unless you continue to have apartheid, then you no longer have a Jewish state. More importantly, there are basic UN documents which guarantee the right to self-determination, not only to Jews but to Palestinians. And one of them is the International Covenant on Civil and Political Rights. Article 1 says all peoples have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural development. And I will briefly argue, there's not time, we can go into it more if you like in question and answer, but I'll briefly argue that the partition resolution of 1947 by the United Nations
there's no reason that we should respect it now. The United Nations, as the International Court of Justice at the time found, had no sovereignty over Palestine, and it had no right to override the right to self-determination of the native population, which did reject at the time the partition of Palestine. And in fact, there was a subcommittee of the United Nations that said, quote, "The UN cannot make a disposition or alienation of territory, nor can it deprive the majority of the people of Palestine of their territory and transfer it to the exclusive use of a minority in their country." And that finding was ignored by the General Assembly. And to the extent that UN resolutions call for the partition of Palestine now, which I don't think they do, but to the extent that people argue they do, the UN to this day doesn't have the right to unilaterally divide any sovereign nation or to override the self-determination of a population. And the main resolution that's cited in favor of the two-state solution, in which one of the states is the West Bank and Gaza, is UN Resolution 242, of course, which emphasizes the inadmissibility of the acquisition of territory by war, which is how Israel it took over the West Bank and Gaza and also expanded its borders to where they are now, if you can call them borders. It also affirmed that the fulfillment of charter principles requires the establishment of a just and lasting peace in the Middle East, which should include the application of both the following principles. And one of them is withdrawal of Israel armed forces from territories occupied in the recent conflict. So one of the things it calls for is withdrawing from the areas that were occupied just before this resolution was made in 1967. It also affirmed the necessity for achieving a just settlement of the refugee problem, and it implied that this resolution didn't solve the conflict in itself. It requested that the Secretary General designate a special representative to try to assist in efforts to achieve a peaceful resolution. So within the text of 242 itself, the UN recognizes that the resolution isn't itself intended as a comprehensive blueprint for a resolution of the conflict, and there's no reason that the BDS movement should treat it that way. Okay, so I'm going to skip to now talking about the academic boycott, and the American Association of University Professors has long opposed academic boycott as a tactic, although many of its members support the goals of the BDS movement. And it says that it opposes the academic boycott because of its long-standing commitment to the free exchange of ideas. And I'd like to challenge that on the basis that opposing the boycott of academic institutions, it's not clear that that would enhance the free exchange of ideas. And I think that the AAUP should reassess its blanket opposition to academic boycotts. I'd like to highlight a couple instances in which it did support the suppression of academic speech in other contexts, in other less controversial contexts. One of them is a series of lawsuits, one of which took place at Yale University, was led by Yale University. Yale opposed, the law school actually, opposed having military recruiters come to campuses and recruit students because the military discriminated against homosexuals, and it said you can't make us help you recruit students. And in retaliation, the federal government withdrew funds from the university, said, in order to get this funding, you need to accept military recruiters on campus. And so there was a lawsuit, it went up to the Supreme Court, and the AAUP supported the right of the law schools not to participate in that form of speech. It said for the government to force Yale to allow recruiters access to students would be to impair Yale's constitutional right to determine for itself the appropriate means or method of expression. And so, in other words, Yale could choose what kind of expression it would participate in. And the U.S. Supreme Court ultimately was not persuaded to protect faculty members' right to send a message about the military's discrimination policy. And in its 2006 decision, Rumsfeld versus Forum for Academic and Institutional Rights, FAIR, the court found that law school's exclusion of military recruiters was not sufficiently expressive to warrant First Amendment protection, and that the government's substantial interest in recruiting for the military prevailed over the university's desire to disassociate from a discriminatory employer. But the courts have protected boycott or conduct similar to what the law schools did as expressive in other instances. For example, the Supreme Court held that when black citizens banded together and collectively expressed, quote, dissatisfaction with a social structure that had denied them rights to equal treatment and respect, the boycott clearly involved constitutionally protected activity. So engaging in an economic boycott was seen as itself being expressive activity and constitutionally protected. And the university's ability to disassociate from the military was important to protect not only their right to express disapproval of discrimination based on sexual orientation, but also the right to try to pressure the government into ending its discriminatory practices. The AAUP views the method of academic strikes as appropriate tools to bring about social change under certain circumstances. It explains that sometimes resort to economic pressure through strikes and other work actions may be necessary and unavoidable means of dispute resolution, even when it involves actions targeting academic speech, such as asking outside speakers not to come to campus during a strike. In furtherance of the civil and educational rights of faculty members and others, the AAUP has supported strikes aimed at securing fair working conditions, faculty governance, health insurance plans, and other goals. In those cases, other means could certainly have been employed to achieve the same ends, such as public condemnation, which is what the AAUP thinks the BDS movement should be constrained to, or debate about the administrative policies the faculty members were opposing. But the memberships determined that other means had failed or proven insufficient, and that a strike was the best available means of pressure, despite the fact that this would temporarily restrict academic discourse, and in some cases, shut down academic discourse if it caused the university to be shut down. In contrast to its support of strikes, however, the AAUP in 2006 summarized its position on boycotts as follows. Members of the academic community should feel no obligation to support or contribute to institutions that are not free or that sail under false colors. Such institutions should not be boycotted. Rather, they should be exposed for what they are, and continued exchange of ideas should be actively encouraged. The need is always for more academic freedom, not less. There's a contradiction, though, between acknowledging the right to choose whom to support or engage and denying the right to boycott. As the AAUP itself acknowledged in its amicus brief to the Supreme Court in Rumsfeld versus Fair, academic freedom, quote, thrives not only on the independent and uninhibited exchange of ideas among teachers and students, but also somewhat inconsistently on autonomous decision-making by the academy itself. There's one other instance in which the AAUP favored pretty striking suppression of speech, and that is when it suggested that it's not only a right but an obligation in the case of countries that violate human rights, have serious and endemic violations of human rights. So the AAUP recently sent a letter to Yale University reiterating concerns about its collaboration with Singapore's government in establishing a campus on that country. It asked that Yale take a number of steps to ensure that academic freedom and human rights were not undermined by the collaboration, and it even suggested total withdrawal from the partnership might be necessary. Its concerns stemmed partly from a worry that the academic freedom of the faculty and students at the Singapore campus would not be honored, but extended beyond that. The establishment of the campus, it worried, might bring about unwanted political implications because it would entail indirectly assisting the Singapore government in achieving greater financial strength and cultural legitimacy. So for the AAUP, Yale has not only the right but the obligation to ensure that it does not collaborate with and legitimize countries with what it called odious laws, such as laws that criminalize sexual orientation, even if that entails restricting academic speech in Singapore. So the question remains whether the AAUP will apply these principles in Israel-Palestine, where there are also odious laws, and where it stands to influence global human rights to a much greater degree, given the United States' much more extensive political, economic, and cultural engagement there. Although the goal of this talk is not to detail the conditions in Israel-Palestine that justify the boycott strategy, something which has been done extensively elsewhere and continues to be done, I'll briefly highlight why the academic boycott in Israel is appropriate. Generally, universities are the intellectual leaders of society and the country's main source of development and training of the political elite. And more specifically, Israeli universities themselves play a role in legitimizing Israel and providing logistical support and training for perpetuation of the occupation and the Zionist structure of the state. And there's a succinct and very good summary of why the participation of the Hebrew University in Jerusalem is a legitimate target for the boycott call. In an open letter campaign to boycott Hebrew University in response to a job opening that was posted for assistant professor position in communication and journalism. And the letter points out that that the university is built on confiscated Palestinian land in East Jerusalem, that the administration restricts the freedom of speech and protest of its Palestinian students. For example, it had forbidden a commemoration event for the invasion of the Gaza Strip in 2008-2009, in which 1,400 Palestinians were killed by the Israeli forces. In recent years, also, the letter pointed out that the Israeli media have highlighted the complicity of Hebrew University in Israeli settler colonial practices in East Jerusalem, and that the university was directly involved in training programs for the Israeli General Security Services, Shin Bet. So universities play a part in perpetuating Israeli apartheid, and as Desmond Tutu pointed out, universities are an intimate part of the Israeli regime by active choice. They produce the research, technology, arguments, and leaders for maintaining the occupation. And more generally, another justification for the boycott is that all other forms of international intervention have failed. And the abuses of the Israeli regime include suppression of education and academic freedom, from the restriction of movement of students and professors to the siege, closure, and bombing of Palestinian schools and universities, sometimes prolonged closure of universities, to a prohibition against teaching the Nakba, which is the dispossession, massacre, and expulsion of Palestinians in 1947-48. And making it illegal to deny the Jewish and democratic nature of Israel. And then finally, I'll say that as any responsible social justice movement should, the Palestinian movement for boycott continually engages in dialogue and re-examination of the bounds of the boycott call. And for example, in July 2009, it issued specific guidelines governing the scope of its boycott, and one of the limitations it placed was that in absence of official Israeli sponsorship, the individual product of an Israeli cultural worker per se is not boycottable regardless of its content or merit. So one of the AAUP's objections, which is that there shouldn't be an ideological litmus test, is a bit of a straw man. So I call on the AAUP and other academic institutions to respect the decision of Palestinian and Israeli academics, as well as their colleagues and supporters around the world, to adhere to PACB's boycott call, not merely to further the human rights of Palestinian Arabs, dissident Jewish Israelis and their supporters, but also to further the fundamental American values the AAUP was created to safeguard. Thank you.
Thank you, Rima, for those remarks. What I would like to do here in the question and answer period is to take a number of questions and then have, and if you want to direct them to somebody, you can direct them to somebody, but I'll take a number of questions first, and then we'll stop, and then we'll have them answer those, and then if there's more time for more questions, we'll have more questions. So do we have a hand? I think we have a hand here, Peter?
Yeah. Recent editorials in the New York Times and lots of other places have talked about certain proposed possible future states of things. Some people have talked about something known as the two-state solution, sometimes specifying where the boundaries would be and sometimes failing to. Other people have talked about something known as a one-state democratic possibility. Other people have talked about the removal of settlers and the destruction and demolishment of the settlement buildings, as was called for in 1980 by the Security Council Resolution 465, a resolution that had no teeth. Now, these are all proposals for something that might happen in some indefinite future. My question is, how do the speakers see the BDS movement as contributing toward bringing about any or all or whatever of these possibilities?
Okay. Over here.
I was wondering if either one of the speakers could elaborate further on the difference between sort of a boycott of any individual Israeli versus what the academic boycott calls for, which is a boycott of academic institutions within Israel. Because I think that's a common misconception about the BDS call, that people think that it limits speech because it targets individual Israeli artists or professors. I was wondering if either of you maybe could talk a little bit more about what it means to boycott academic institutions as opposed to individuals.
Right here.
I was wondering, what has been done?
Would you raise your voice, please?
What has been done already on the NYU campus? I'm new to the university, so what movements have been made? What professors have been talked to? Who has been approached? Like, what groundwork has been established already? And what resistance has it been met with here at NYU, especially?
Okay.
I want to say first thanks to you both for the excellent presentations. Rima, I wanted to ask you, in concrete terms, what strategies should activists use for bringing about what I share with you, this crucial idea of moving beyond just talking about the occupation and getting down to the real issue, which is Zionism? What strategies can we use, given the fact that there's a lot of resistance among many solidarity groups to go that far? How do you see moving the BDS movement forward to being a movement that addresses the underlying issue of the problem of a Jewish state?
Okay. Any other? One last question, then we'll. Yes. Mitchell.
So Netanyahu's nephew was one of the resistors inside of Israel itself.
Right.
Refused to go into serve in the military, and he went to jail. There have been thousands, actually, of resistors who refused to fight and so forth. It seems to me that it would be really good if students at NYU and elsewhere would invite them to come to the campus and to provide a forum for the resistance inside of Israel, and join that with people from Palestine speaking also, and put them together in a coherent way. And I was wondering how much of that is being done on campuses around the country, in the U.S. today, and what has the response been to that? Because it goes two ways. Just one, it goes, they influence us, but we also give courage and influence them by providing the forum as well. It's a two-way street there.
Antonia?
I just want to respond really quickly about the two NYU questions. That first of all, and the TIACREF campaign that Barbara talked a lot about is, I think, still, and certainly has been in the past few years, very active at NYU, just not inside the law school, which tends to be quite isolated from the rest of the university. And I don't want to put her on the spot, but there is somebody who's involved in SJP, so if she wants to speak up at any point, please do. And as far as inviting the resistors, I'm not sure if we've done that recently or that's happened recently, but you might also be able to touch on that. Do you want to say something?
I guess I didn't hear what you talked about for the campaign, so I don't know how much of it's been like announced or to what extent
Maybe just like a really brief 2 sentences.
Okay, so, hi, I'm Sarah. I'm part of Students for Justice in Palestine at NYU. And so 2 years ago now, 2.5 years ago, we started the TIF campaign on campus, which asks faculty and staff members to sign a petition saying that they want TIA craft to divest from corporations that are invested in the occupation. And we have 214 faculty members who've signed on. The majority of them are in College of Arts and Science. This is directly to your question. College of Arts and Science and Gallatin, a few law school, med school, other schools, but mainly in the undergraduate sort of hubs. And we just sort of recollected as a club this year, so we haven't sort of made further steps.
So, I take it that the questions regarding NYU, these particular panelists are not really au courant about what's happening here at NYU. So, thank you very much, Antonia and Sarah, for your input on that. I'll take, since there's basically only 3 questions that have been asked that these panelists can really address, I'll take 2 more questions, one here and one here. You go ahead.
Yes, this is in response to what the gentleman in the leadership said about inviting Israeli protesters. 2 or 3 years ago, 2 young Israeli resistors were here, 2 young women. Shemenetzim, I think that's how it's pronounced.
Can you raise your voice?
I'm speaking as loud as I can.
Okay.
If you can stand up.
These 2 young Israeli resistors came to speak here at NYU, 2 young women. I think they're called Shemenetzim.
Schmidt-Esteem.
Sorry, I didn't pronounce it properly. But they were invited here, but yes, I think it would be wonderful to invite these people, especially Netanyahu's nephew.
Okay, Professor.
Yes, we have 2 litigators in the panel, and we're in a law school. Some represented at somewhat degree in the audience here. My question would be, to what degree does domestic law have a role in this movement, recognizing, as Rima, as you pointed out, there have obviously just been so many decades of violations of international law that it seems almost frivolous and ridiculous to mention them again. So what role do young students domestically have to play in this movement?
So, you all understand, maybe, Barbara, you want to go ahead first and then answer what questions that you feel that fall within your purview, and then Rima, you can answer those that you feel that you can respond with.
The microphone.
Yeah, I'd like to start with that last question first. Actually, it was a subject I intended to cover in my talk and didn't get to. The role of domestic law is this. That was one of the early weapons in the opposition to BDS. There was quite an active, it seemed like a whisper campaign going on behind movement backs into the ears of administrators and other people running institutions that were being targeted for BDS activism, arguing that it is illegal under U.S. law. And there are provisions of U.S. law called the anti-boycott provisions of the EAA, the Export Administration Act, and there are Treasury regulations as well that to have anti-boycott provisions. These provisions do not apply to our work, and it gradually became clear to me that the reason no one ever was willing to state the argument openly or engage us directly in dialogue on the question is that this is so clear that these anti-boycott provisions do not apply. Aside from the fact that the law itself expired years ago, leaving these regulations, anti-boycott regulations, without the law that they were enacted to implement. Each president since expiration, including Obama, has asserted the authority under the Presidential Economic Emergency Powers Act to continue those regulations in effect under the Emergency Powers Act. And without any law any longer that they are based upon, founded upon, which in itself is like an open invitation to a legal challenge if they are enforced against BDS. But I can tell you that the Department of Commerce, which is charged with administering those regulations, does not interpret those regulations itself as applying to BDS activity. And I think they know enough to know that if they interpreted the provisions as applying to BDS activism, that would threaten the constitutionality of the anti-boycott provisions entirely. Because to apply these provisions to boycotts, economic boycotts called for human rights purposes, would be unconstitutional under US Supreme Court law, very clearly. And Supreme Court law, I'm not talking about AAUP or anybody else, I'm talking about the US Supreme Court, which says, and this was the basis for the founding in constitutional protection for the US civil rights movement and activism and the boycotts that were engaged in connection with that activism. So the constitutional protection for economic boycotts is clearly established in law by the highest court of the land and has been for decades. And in addition to that, the law itself does not, by its own terms, if it, which are parroted by the regulations, does not encompass BDS work, because the law itself refers only to encompassing boycotts called by a foreign country against a friendly country. One friendly country is specifically identified in legislative history, namely Israel, and the boycott activity that was the target of the law was the Arab League boycott. And the law is drafted in neutral language so that it encompasses any boycott called by a foreign country against a friendly country, but that was the purpose of the statute, was to get, to nail US cooperation with support for the Arab League boycott, which is not this. BDS activism, first of all, is called for from abroad by NGOs in Palestine, civil society organizations, private organizations, not an official state call. That takes it entirely out of the statutory scope in itself. More fundamentally, perhaps, certainly as fundamentally, is that BDS activism comes from US organizations that are calling for the boycott activity. JVP, Adala New York, the US Campaign to End the Israeli Occupation, all of these campaigns that are out there now have been created by US organizations and not foreign countries. Furthermore, they are campaigns not for the economic benefits of those who support them, but for the advancement of human rights issues, which is squarely the protection, the kind of activity that was held to be protected by the US Supreme Court. So divestment, by the way, is not even encompassed by any form of divestment, is not encompassed by the statute. So that's why we were never told or given any written presentation of the argument, because it is so lame. And it is no longer, I haven't seen it for a while. The current, the argument du jour is that BDS activism and criticism of Israel is essentially hostile to the state of Israel and therefore anti-Semitic. That is the current argument. And as anti-Semitism, it is religious discrimination and hate speech, and therefore within the ambit of Title VI as a variety of ethnic discrimination, a very strained position, which was adopted as a new interpretation of Title VI by the Department of Education's Office of Civil Rights, while coincidentally it was under the direction of Kenneth Marcus, who is the Brandeis Center director and very, very active in the movement to destroy BDS. He is now back at the Brandeis Center and actively advocating the complaints against universities under Title VI to implement the reinterpretation that was made under his administration, and so far has lost every such challenge. But that's the current argument, and it is fundamentally flawed, because BDS activism is not directed against Jews. It is directed against the official state policy of a nation state. And the notion that there is one nation state's policy that is immune from criticism is astounding under the US Constitution, just astounding. And when people hear it, their jaws drop, including many Israelis who are very embarrassed by it. So it is not a form of anti-Semitism. Most of the Jewish population in the world is outside of Israel, living in the diaspora. So activism against the state of Israel has nothing to do with the vast majority of Jews in the world. And BDS activism is committed to ending the day that Israel agrees to the goals of the BDS movement. And I'm talking about BDS against Israel itself. So it is clearly not directed against the Israeli people, let alone the Jewish people, but against conduct perceived as being misconduct by activists, and that indeed is defined as misconduct under the Fourth Geneva Convention and any other bodies of international law. So, and those are the arguments out there. There are no arguments out there anymore for a long time on the merits of the rationale for BDS activism. That argument has disappeared. So I would like also to talk about, if I'm correctly understanding the question, recent editorials on the nature of a proposed future state or states or whatever shape. What are our thoughts on the issue? Is that
the practical use of BDS is to bring about something like one of those proposed futures?
Mm-hmm. I see the purpose of BDS activism myself as to achieve the goals of BDS activism, however they may be achieved. And if that's by two states, that's certainly the method that both Israelis and Palestinians would prefer, but probably is impossible. It seems to be viewed as impossible by virtually all Palestinian scholars with great sorrow and reluctance, as well as by many others, because what we have in Palestine now is a vast infrastructure. The settlements are cities. They have schools and hospitals and police forces and theaters and libraries, and people are born in them and never know any other way of life. And there are many of those people and many of those settlements. Many of the people in those settlements would leave, actually, if offered similar economic inducements that they've been offered to live in these settlements, if they were offered those same inducements to live somewhere else in Israel. Most of the settlers would happily leave for that. There is a hardcore of ideological settlers, they're called, rather than economic settlers, who would leave for the same inducements, who would not leave, or say they would not leave. But remember in 2005 when Israel pulled out the settlements in Gaza, there were ideological settlers there as well, who said they would never leave. And guess what? They all left. Every last one of them. they destroyed their greenhouses so that they would not be available to Palestinians to use, but they left. So, everybody is saying the two-state solution is impossible. I have to give that a lot of credence. A one-state solution right now, if it were implemented, would be an invitation to really ethnic cleansing of a very tragic sort. Because the only way a one-state solution can work in a way that would not carry with it horrible human rights violations is if it is founded on a very serious commitment to equal rights by Israel. There has to be a commitment to equal rights. Anything else?
And the viola.
Oh, Viola, you want me to talk about Veolia? Oh, people asked about Veolia?
No. You were going to address it in your talk.
Right, Veolia is a huge company. Many people don't know that it is the largest water treatment, water management company in the United States. It also runs vast networks of waste management facilities in the United States and elsewhere around the world, including in Israel and the occupied territories, where it runs a dump, garbage dump. The piece of Palestine has been turned literally into a dump for garbage from the settlements and from Israel, which is carted in. And it runs primarily, or did primarily run, small private transportation systems like handicapper vans in the United States, senior citizen van services, all of the super shuttle buses, Veolia. Independent contractors, however. And it was one of the members of the consortium that Israel put together to build the light rail system connecting the settlements in the West Bank with Jerusalem, and the entire project is illegal under international law, as being a project, using, occupied land, expropriating it for the benefit of the occupying power and the people that it has unlawfully transferred into the occupied territories, also illegal under international law. The entire project is illegal for that reason alone, but it is also one of the most despised symbols of the apartheid system that occupation is, because the roads, the lines connect only the settlements to Jerusalem. So if you have no reason to be in the settlements, you have no reason, no occasion to use the light rail system. And the buses that it runs in the occupied territories run on roads that are accessible only to people who have license plates that are Israeli issued license plates. So no Palestinian vehicles are able to operate on those roads unless they have like the taxi van license plates that Israel will issue to some Palestinian taxi services. So Veolia has become, in a very real sense, the symbol of the apartheid aspects of occupation around the world, and it has been the target, therefore, of much of the boycott and divestment activism in Europe as well as in the United States. And it is now it has suffered so much loss of business, almost $20 billion worth of lost contracts that somehow followed hot on the heels of boycott and divestment campaigns targeted against that particular contract. Coincidentally, it has a debt burden in virtually the same amount of money as its lost contracts. That is so serious that its credit rating has been downgraded, and it is in serious economic straits. And it has announced that it is selling its transportation division. It has sold off its interest as a member of the consortium to build the light rail system, and it tried for a long time to sell the operating rights without success. No one would buy it. The only entity that eventually was willing to buy it was the Israeli bus system, Egged, which doesn't know how to run a railroad. And so the only way Egged was willing to make the offer to buy it was if Veolia stayed around long enough to show them how to run a railroad, which Veolia has agreed to do. So Veolia is actually still around running the railroad to its sorrow because it is suffering mightily from BDS.
Okay, so there was one question about what it means to boycott academic institutions as opposed to individuals. And I'd encourage you actually to read the statement, the thoughtful statement that was written by the boycott movement about it, and I can get you the exact website if you like. But basically what they're saying is that we're not boycotting individuals based on viewpoint. We're boycotting institutions that participate in perpetuating Israeli apartheid. And that's a really important distinction that it sticks to. And in fact, recently there was a YouTube video in which George Galloway was shown refusing to speak to debate an Israeli. And once he found out the guy was Israeli, he got up and left. And the boycott movement in Palestine actually issued a statement saying, look, we're not boycotting individuals, we're boycotting institutions. And so of course individuals like George Galloway are free to define the parameters of their own personal boycott however they want to, but that's the way that the Palestinian movement has decided to draw the boundaries. And then the question about strategies for talking about Zionism when advocating for BDS. Well, for starters, I'd say it's important not to just assume that international law requires merely withdrawal from West Bank and Gaza. I think a lot of activists do that just because they want to be conservative. But we should re-examine the basic international law documents that give human rights to Palestinians and all others, and talk more amongst ourselves and others about what self-determination means, what it means when applied in Palestine, and then what the significance of the different Security Council resolutions are, whether the partition plan, the British mandate, whether they're legitimate, and whether we should continue to abide by them. And then also not just to limit discussions to talk about settlements. More and more there seems to be attention drawn to the inequalities within Israel itself and the discriminatory laws in Israel. But it's also good to talk about the whole structure. How do we, if we want to end the violence, how do we devise a structure that's actually just, that will give lasting peace, as opposed to just accepting the status quo. And ultimately what our conclusion should be is that the main goal of BDS should be self-determination for the people who live in the land. And of course that includes the Jewish Israelis. But not just the people who live in the land, but the legitimate residents of the land is really what self-determination is. And it's increasingly now in terms of popular opinion, and of course the BDS movement of Palestine is a better judge of this than me, and more polls can be conducted, let's say. But the trend is that more and more Palestinians are not accepting this sort of two-state framework that has been imposed on them, I'd say, by virtue of the political realities after the '67 war. More and more Palestinians are saying, why don't we just have a democratic state? We're living on top of each other. Why can't we just live together? Both in the West Bank and Gaza and within Israel itself. It's a mixed population. And the polls that are conducted now, that have been conducted up to this point, don't really include all of the people who are entitled to exercise self-determination. So, oftentimes they include only the residents of West Bank and Gaza. Well, what about the refugees, many of whom are not from West Bank and Gaza and may prefer to be part of a democratic state in Israel, rather than be confined to this little piece of territory that's not contiguous. So I don't think that we have to take one position or another, but we should simply argue for self-determination and then find out how that self-determination would be exercised, and it's up to the Palestinian people, not to the United Nations or to outside observers. And the BDS movement is good at being a grassroots movement and sticking to that. It's not a few people in the West Bank who are making all the decisions. It's very much a democratic movement. And then I just add one other thing about the law question. So in terms of defending against legal challenges, which will, I'm sure, come about, and especially, for example, the ones that Barbara mentioned, the main defense against them, I think, and she alluded to this, is the First Amendment. And oftentimes when we talk about BDS and academic freedom, we talk about the academic freedom of Israelis. By engaging in an academic boycott, are we harming the academic freedom of Israelis to participate, let's say, in the US academic discourse? And really, it should be framed not just in terms of academic freedom of Israelis or even of Palestinians, whose academic freedom, and dissident Jews in Israel, whose academic freedom is suppressed, but in terms of the academic freedom of US institutions to determine for themselves what kind of academic discourse they'll participate in. And that's the freedom that the AAUP vigorously and eloquently defended in other cases, in other contexts. And in fact, US courts, including the Fourth Circuit and the Seventh Circuit recently, have reiterated that academic freedom isn't just the right of individuals, it's actually an institutional right. The state can impose on universities requirements about about the scope of discourse. It's up to universities to decide what they're going to participate in, and in the U.S., whether they're going to further Israeli occupation or whether they'll try to be part of the movement to end Israeli apartheid.
Another question.
yeah.
that we didn't answer.
Okay, what I'm going to do is ask the two panelists to touch on any points that they did not get a chance in the 20 minutes they have. I think it's getting late and we want to, people are tired, but unless there's any real pressing question, I'd like to have both of the panelists address anything that they missed in their presentation, but no longer than 2 minutes apiece, okay?
Okay, I would like to answer a very important question that was asked that got lost in the shuffle about, what about moving the movement forward? And that is always the most important question to any movement activist. And I think we have been enormously successful to date, enormously successful. The dialogue is completely different now than it was 2 years ago. The editorial that was published, it wasn't an editorial, the article on the two-state illusion that was published in the News of the Week Review's front page this past Sunday would have been unthinkable a couple of years ago, utterly unthinkable. And told it like it is, pretty much. I mean, I had some quibbles with it, but wow, it was incredible. And there it was on the front page of the Sunday New York Times News of the Week in Review, the Palestinian perspective, something I had never thought I would see for years and years. I think that we have been incredibly effective doing what needs to be done, which is changing popular perceptions and opinions. As with Cuba, that is what leads to legal change and change in policy by the United States. In fact, many Jews are very deeply embarrassed and troubled by what they're seeing from AIPAC and its sister organizations, because it's very troubling to them as sensitive people who like to think of themselves as egalitarians and progressives. And there are many Jewish students on campus who don't even want to be associated with Jewish organizations on campus because they're so embarrassed by what they're seeing. So what we're seeing actually is that if anything is going to destroy Jewish identity, it is going on the way things are going on in Israel now. Because it is ultimately a bankrupt proposition that a country that calls itself a democracy, and one of the first world nations will be allowed by the other countries that hold and enjoy such status to function on what is essentially an apartheid system. It's not going to be allowed. It's not going to be tolerated. It's intolerable. It will infect all of the rest of the other countries that have that same status. And it will destroy Israel unless Israel changes and accepts that it has to accept equal rights. It has to. It has no choice. It's the only civilized way to do business. So I think if we stick to the basics, those are the basics, I think we will and must prevail.
Thank you. All right. I think we're gonna wrap this up. I wanna thank everybody. No, she doesn't wanna speak, she's already said. I wanna thank everybody for coming. I think it's been a really engaging and thought-provoking presentations by our two speakers. I wanna thank them again for traveling from their respective locales in New York.
Long live the Midwest.
And we gave them Chinese food. We gave them Chinese food before the presentation. So thank you so much for coming, and let's keep up the good fight. Thank you.